roll call. If each person will identify themselves and verify that they can hear the others, we will open the meeting. And I will start by stating that this is Ronald Crutcher, chairman of the board, and I am able to hear everyone. What about you, Mr. Adams?
This is Glenn Adams, and I'm able to hear everyone.
All right, Mr. Hughes.
This is Josh Hughes, and I can hear everyone.
All right, Mr. Lee.
This is John Lee, and I can hear everyone.
And we've got Mr. Schultz.
This is Kenneth Choate, and I can hear everyone.
All right, we have a full attendance, and we are ready to conduct the business of the day. And I will turn the meeting over to Mr. Cook to lead us through the agenda.
Thank you, Mr. Chairman. If there is no objection from the members and subject to Executive Order number 60, the Board of Adjustment Appeal members have determined that it's necessary that this meeting be held electronically to protect the health, safety, and welfare of the public due to the COVID-19 pandemic. Are there any objections? Hearing none, let the minutes reflect the board has made the determination to conduct this meeting electronically. I do want to remind everyone that each vote must be by roll call vote. The chairman will call the names, at which time you will provide your vote. Prior to making a motion or second or asking a question or making a comment, please identify yourself. Mr. Chairman, you can proceed with approving the minutes.
The first order of business is the review and approval of the minutes of the last meeting. And if are there any questions or comments about the minutes?
Mr. Chairman, it's Glenn Adams, and I'd like to go ahead and move that we approve the minutes as submitted.
Proper motion's been made. Do I hear a second?
Mr. Crutcher, this is Kenneth Choate. I'll second the motion.
Motion's been made, seconded. Are there any, give you the opportunity, any other comments or questions? If not, we will have a roll call vote, beginning with Mr. Adams.
This is Glenn Adams, and I vote to approve the minutes.
Mr. Schultz.
This is Kenneth Choate. I vote to approve the minutes.
Mr. Lee.
This is John Lee, and I vote to approve the minutes.
Mr. Hughes.
This is Josh Hughes. I vote to approve the minutes.
And this is Ronald Crutcher, and I vote to approve the minutes. The minutes are approved unanimously, and I'll turn it back to Mr. Cook.
Thank you, Mr. Chairman. Let the record reflect that adequate public notice was given both to the home builders and to the public. Without objection, we will hear Crescent Homes, Drees Premier Homes, and the Jones Company. I'd like the minutes reflect that no additional documentation has been provided by the appellants. First argument that the appellants make is that they've obtained vested rights under the Vested Rights Act of 2014, so the lots at issue are not subject to the impact fee. The act provides that should a developer receive preliminary plat approval from the local authority, the development standards in place shall remain the same through the course of the development of the property. So the appellants here are arguing that the impact fee is a development regulation or development standard. However, when you look at the act, development standards is defined as including local stormwater requirements, local construction standards for buildings, streets, alleys, curbs, sidewalks, lot size, etc. It all has to do with the actual development of the subdivision. And in fact, the appellants can develop the subdivision without ever having to pay the impact fee, since the impact fee is due on approval of a building permit. However, should the board find that the impact fee is a development regulation triggering vested property rights, we maintain that the applicants have provided no evidence that it received any approvals from the planning department or planning commission for the property at issue prior to the adoption and implementation of the education impact fee. The second argument appellants make is that the county is required to calculate each subdivision with their own calculation, and that the proceeds from that calculation be used only for projects that benefit that particular subdivision. The Private Act does not provide this. It grants the intent of it is to grant the county commission the authority to establish a process. Whether they decide there will be one district, two districts, or several, that is a legislative action and decision, and the county commission has made that decision. They have created two subdivision or two sections, one FSSD and one outside the FSSD, as required by the Private Act. And for these reasons, Mr. Chairman, we ask for these appeals be denied.
Thank you, Mr. Cook. You've heard the recommendation from the staff. Are there any questions or comments?
Let me ask Mr. Cook a question, or maybe Mr. Horn. I did not, normally I hear the gals say that this meeting is now being recorded. I did not hear that. Are we being recorded?
We are, I believe, yes, sir.
Okay, then I will go ahead and make a motion that we deny these appeals. Mr. Chairman, this is Glenn Adams.
This is John Lee. I second that motion.
The motion has been made and seconded to act upon these requests by denying them. Are there any questions or comments? Hearing none, we will have a roll call vote. I will start. This is Ronald Crutcher, and I vote for the motion, which is to deny. Mr. Hughes?
This is Josh Hughes. Vote for the motion to deny.
Mr. Lee?
This is John Lee. I vote for the motion to deny.
Mr. Arnold? I'm sorry, Mr. Adams?
This is Glenn Adams, and I vote for the motion to deny.
And Mr. Scholl?
This is Kenneth Cho, and I vote for the motion to deny.
All right, the votes are unanimously for the motion, which is deny. So the appeals are denied. Back to you, Mr. Cook.
Thank you, Mr. Chairman. The last appeal that we have is from Celebration Homes. The applicant has provided no explanation for the appeal, nor have they checked any of the boxes. Based on the previous appeal submitted by this applicant, the county maintains that the impact fee is not a development regulation or development standard, and then therefore vested rights do not attach to this lot. Further, the county maintains that it adopted the educational impact fee in accordance with the authority granted under Chapter 120 of the 1987 Private Acts. There is no requirement the county create a new impact fee rate for each subdivision, and the proceeds raised must be spent in a manner that only benefits that particular subdivision. For these reasons, Mr. Chairman, we ask for these appeals be denied.
Thank you, Mr. Cook. You've heard the staff's position. Are there any questions on this item? Hearing none, the chair would entertain a motion.
Mr.
Chairman. Go ahead.
This is Kenneth Cho. I make a motion that we deny this application for appeal.
Mr. Chairman, this is Josh Hughes. I'll go ahead and second that motion.
All right. Proper motion's been made to deny and seconded. Are there any questions or comments? Hearing none, we will proceed to vote, starting with Mr. Lee.
This is John Lee, and I vote for the motion to deny the appeal.
Mr. Adams. Mr. Adams. We'll come back to Mr. Adams. Mr. Shaw,
This is Kenneth Choate. I vote for the motion to deny.
Mr. Hughes,
This is Josh Hughes. I vote for the motion to deny.
coming back to Mr. Adams,
This is Glenn Adams, and I vote for the motion to deny.
this is Ronald Crutcher, and I vote to deny. The motion has passed unanimously. The appeals are denied. Is there any other business to come before the board?
Yes, sir, Mr. Chairman, this is Joe Horn. A couple of items. First of all, as Bobby alluded to earlier in the meeting, we still have several appeals pending, enough to for sure get us through the month of October. The slightly better news is the governor has granted us a continuing authority to hold these meetings in this manner, and so I think that will, even if we have to continue, remain somewhat more convenient than y'all having to come down here and see us those two times. But that's all I will have.
So we will continue meeting until there are no appeals turned in, and or other actions by the Williamson County Commission. Is
I
there
have a
any other-
question.
Go ahead.
Since the Supreme Court has ruled, and I guess basically confirmed the position of the county, does the county still have to put the money in escrow if there's an appeal? How does that work? And I would have thought that the county and their counter argument to the appeal would say the Supreme Court has ruled this is invalid.
Yes, John, you're correct. There's no reason we need to include or deposit these funds into an escrow anymore. The Supreme Court obviously has denied their motion to hear this appeal, so the case is actually over. I do want to tell you that every time they do appeal it, there would be a chance, if you all decided to uphold appeal, that we would have to release that money back to them or to that particular development for that particular appeal. But as it stands, there is no longer any case from the home builders against the county, and those funds are able to be spent.
Bobby, if I may ask you one further question on that. At what point did we get to where you can just say that the court has decided instead of having to go through this whole conversation that you do?
Never.
Okay.
Sorry to break it to you, but we'll have to, as long as they appeal, we have to go through the steps to give them their right to appeal.
Okay.
This is Joe Horn. I will add this too. This decision, or lack of decision perhaps, only came down last Friday. So it's a little difficult to say right now. We had as I noted, we have a number of appeals stacked up, and the next several weeks will tell whether or not this is going to continue or whether we just have to take action on the ones that are pending. I have some opinions, but what's going to happen next? But we'll just, as long as we're getting the appeals, we'll be hearing them, I presume. But we, as Bobby noted, we have a couple of ideas percolating around with the, given this outcome.
Remind us again, how long can we wait before we act on an appeal?
30 days, right, Joe?
Mm-hmm. It's a 30-day window. We have to meet we have to hear their appeals somewhere between the 30th day and the 45th day. And as I said, go ahead.
So is there a possibility that we could go to monthly meetings?
Mr. Chairman, that is one of the things we are looking at, because the county commission, the act actually provides us the ability to create the process. When we created the process like this, it's similar to our privilege taxes. We never foresaw these appeals, the amount of them that we've had come before us. But that is one of the ideas we're looking at, is to extend the time that we have to actually hear the appeal.
Mr. Chairman, I want you to understand now, if we do that, you're getting into my budget. And we need to be careful, before we jump into anything.
You're right. Like I say, after all these years, I'm on the county payroll, and I'm with you, Mr. Adams. It's it gets into your peanut butter and cracker money. Okay,
Well, maybe
enough. If there's no other business, I will declare this meeting adjourned.